Oh, oh. Okay, we're on the record in the matter of the people of the state of Michigan versus Brandon Michael Jean, file number 22-00736 FY. Council appearance, please.
Good morning, Your Honor. Andrea Lacey, appearing on behalf of the people.
Good morning, Your Honor. Dwayne Silverman from the Office of Public Defender on behalf of Brandon Jean, who I see standing in the hallway at the jail, and he is on screen.
Thank you. Mr. Jean, can you hear us?
Yes, ma'am, I can.
Okay, very good. Today's the date that is scheduled for a preliminary examination. My understanding is that there is going to be a waiver. Is that correct?
Yes, Your Honor.
Yes,
My
Your Honor.
understanding that the people and the defendant are going to unconditionally waive the rights to preliminary examination and ask that this matter be bound over to circuit court at this time.
Thank you. Is there an offer?
Your Honor, the offer in circuit court would be for Mr. Jean to plead as charged to the armed robbery. In exchange for that plea, the people would dismiss the habitual offender fourth offense notice. More than likely, there would also be some sort of sentence agreement, but that will take place in negotiations with the circuit court prosecutor.
Mr. Silverthorne?
Your Honor, we acknowledge the offer, although we would state for the record that this waiver is not being given conditioned on that offer, and this is a true unconditional waiver.
Did you say something, sir? I didn't hear you.
No, I did not.
Okay, very good. Okay, so Mr. Jean, do you understand that you have a right to have a preliminary examination here in the district court?
Yes, Your Honor.
And is it your understanding that at the time of your preliminary examination, you have the right to have the prosecution establish their burden of probable cause? So they would have to bring sufficient evidence to establish that there is sufficient probable cause that a crime was committed and sufficient probable cause to charge you as the defendant who committed the crime. Do you understand that?
Yes, Your Honor.
Do you wish to unconditionally waive your right to have your examination today?
Yes, Your Honor.
Okay, so the unconditional waiver, sir, means that once you waive it, you can't change your mind and have the exam. This matter will be bound over to the circuit court without any hearing here in the district court to determine probable cause, okay?
Yes, Your Honor.
Okay. Is anybody threatening you to get you to enter this waiver, sir?
No, no, ma'am.
Is anybody promising you anything to get you to waive your right to the preliminary exam?
No, no, ma'am.
Okay, and you're waiving it freely and voluntarily?
Yes, Your Honor.
Okay, I'll bind the matter over to the circuit court for a bind over date of June 8, 2022. You do not need to appear in circuit court at that time. That's just the date they'll get the file from this court. You will not have an arraignment in circuit court unless Mr. Silverthorne files a motion with this circuit court requesting such, okay?
Yes, Your Honor.
Any additional matters for the record?
Nothing for the people, Your Honor.
Inquiry, Your Honor. I have signed the waiver bind over, but I have not had Mr. Jean sign it because I didn't know if he was going to be brought in here. Would you like me to inquire if I can sign on his behalf?
We haven't had these signs since COVID, so we just do them on the record.
As I said, it's been a while.
Yeah. So I don't think it's an
That's
issue.
fine, Your Honor.
No problem. So you're all set. Bond will continue. You're all set, sir. Thank you.
Thank you.
Your Honor, have a great holiday weekend.
Same to you, sir.
It'll be a while, okay?
So. No, it's okay. You can just stand right here.
Okay. On the record in the matter of the people of the state of Michigan versus Sandra Gardner, file number is 22-01110FY, council appearance.
Morning, Your Honor, Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Robert Plummer of the Public Defender's Office appearing on behalf of Ms. Gardner, who stands to my right.
Thank you. How are you, Ms. Gardner?
Hi.
Today's the date that it was set for preliminary examination. How are we proceeding at this time?
Your Honor, this time my witness is actually unavailable. She is out of town at this time. Also, I believe that we are still waiting on additional discovery from her. I know that Mr. Palmer had requested some documentation, additional documentation from what we were able to provide previously. I don't know if he's received that. I do not have that. If he has, or any way to verify that, yeah. In addition, Your Honor, I was informed that this may have been a plea, which would make sense considering the facts that I have. So I would ask at this time, Your Honor, that this be adjourned out so that we can get the witness here and proceed the exam.
Mr. Palmer?
Thank you, Your Honor. First of all, it is correct that I've requested additional information. I have not received that information yet. Nonetheless, we are here today. We are as prepared as possible as we could be today. We would ask that the matter be dismissed for lack of probable cause. I'll leave that in the court's discretion.
Okay, thank you. Looks like the defendant was arraigned on May 12th. I don't know where the witness is. You've been in communication with the witness, is that?
I talked to her last week,
Oh.
because I asked for some information from her so I could make an offer to Ms. Gardner. But she did not inform me of the position at that time. I was informed after she got her subpoena.
This witness is the agent of Quality Dairy?
Correct.
Okay. Okay, but it is a holiday weekend. I don't know if the person had previously arranged plans prior to getting a subpoena, which they probably didn't get a subpoena until about a week ago, based on the time in which Ms. Gardner was arraigned. It also sounds like there's some outstanding discovery. So based on that, I'm going to grant the request for an adjournment, because if I grant the dismissal, it's just going to get reissued and you're going to have to come back to court to be arraigned. And that's not in the interest of judicial economy. So I'll go ahead and grant the adjournment.
Thank you.
June 7th at 10:30. Because of that, I'm going to find the cause to waive the 21-day timeline. You said, what day again? 7th, the 17th. Look at that. That's a exam day? June 17th at 9:30. June 17th at 9:30 work?
Yeah, June 17th at 9:30 works just fine.
Okay, very good. Do you have any questions today, ma'am?
No.
Okay, we'll get you a copy of the notice to appear if you have a seat there. Any additional matters for the record?
Nothing for the people.
Nothing to the attention.
Thank you, you're all set. Ms. Donnelly and Mr. Fife, I just forwarded you an email that I received. Did you get it?
Yes.
Okay.
And I don't believe we'll be running an exam on that today, though also have some case here.
Oh, cool.
And if we can go on the record for that.
Sounds good.
Yeah.
There's like 100 links and it's all some random.
Your client's in the jail.
He's downstairs.
I don't know what it
yes.
is.
I'll have them put them on.
Okay.
Did you just see your attorney? Yeah. Do you know
Can you hear me in the jail?
Yes, Your Honor.
Okay, this is Michael Thomas.
Yes.
Okay, we're on the record in the matter of the people of the state of Michigan versus Michael Thomas, file number 22-01106 FY. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Michael Thomas, who is appearing from the Lansing Police Department.
Thank you. And today's the date that was set for a preliminary examination. How are we proceeding on this?
Your Honor, I think both parties agree there needs to be an adjournment in this matter for several reasons. First, Kayla Lloyd joined the Zoom call today saying while she was subpoenaed for court, she was unable to appear today due to not having a ride. Now, this is the first contact that people have been able to actually confirm with Miss Lloyd. We got contact information from her that now confirms that someone we getting emails from in the past is indeed her. And because of that, frankly, things need to be explored in the interest of justice and in my personal belief, lying more into the favor of Mr. Thomas as to whether certain things in this case can be charged or not. But additionally, it also confirms a old suspicion that one of the people he has been engaging with from the jail is in fact Michaela Lloyd, and that was actually confirmed more by the officer Hutchins, who is here to testify today, confirming that the physical layout of the place in the video visits is indeed the apartment of the victim, Michaela Lloyd. Because of that, that needs to be investigated. We also need Michaela Lloyd here in person to testify, and the emails that we've gotten from that individual in the past need to not only be turned over, but looked at thoroughly in order to ensure that we're not charging Mr. Thomas with something that he should not be charged with. Because of all of those factors in this Gordian knot of confusion, I believe that an adjournment is necessary in this matter.
Okay, I also want to put on the record that the court received an email directly from Ms. Lloyd. Ms. Lloyd should not be sending the emails to the court directly. She should probably have contact information with the prosecutor's office.
Have it now.
Or an advocate at the prosecutor's office so that the court doesn't receive emails from her.
I do, they just don't respond.
I'm sorry. Someone's talking, so I'm gonna mute them. But I did forward that email over to your attention.
And we received that. Thanks, Your Honor.
Okay, thank you. And so you do have contact information for Ms. Lloyd?
As soon as she joined the Zoom call, I got that information from her to make sure that there could be a line of communication that we can confirm is her.
Okay, sounds good. So,
Frank, Your Honor, there's been a problem of overlapping identities in terms of older contact information, which is why we could not confirm for a very long time that we're actually conversing with Miss Lloyd. But we are able to as of 20 minutes ago.
okay. Ms. Donnelly, did you want to say anything?
Your Honor, I would stipulate to the adjournment. I do want Miss Lloyd to be here in person so that we can proceed with this preliminary exam.
Okay.
Excuse me,
Yes.
I haven't spoken to my lawyer about any of this. For her to be sitting here agreeing to the adjournment without speaking with me first, I feel like is out of the ordinary. I've been sitting in jail for over 3 months now. Charges has been dropped.
But not on this matter.
Coming
I
in,
can actually explain that, Your Honor. So I signed this case months ago and months ago. He was picked up as a bond violation on his other cases with
Which
this
was
being the
dropped.
predicate for it. For whatever
which was
reason,
dropped.
for whatever reason, even though I signed the complaint and sent it off to be sworn to, that didn't happen until very recently. And
I still
dates
have been
reflected
sitting
in
here.
the actual.
Okay, maybe I can explain to both you and then the person who's identified as Ms. Lloyd that you don't get to just talk over people in a
I
courtroom.
apologize,
And we're talking,
Judge
and
Simmons.
you talking about stuff that's being out of the ordinary. Well, it's out of the ordinary. It's rude to talk over the
I
attorney
apologize.
and the judge. I have a court recorder. She's sitting next to me. She's got to try to write down everything that's being stated here. She can't do
I
that if
apologize.
everybody's talking over each other. So I'll
I'm
give you an
sorry.
opportunity to talk. Stop
wasn't
talking because
finished.
you're still, stop talking and listen. I'll give you an opportunity to talk, but it can't be when someone else is talking, okay, sir?
Oh. Yes, Judge, but I wasn't finished speaking.
Okay. I recognize that, but I recognize that you haven't spoken to your attorney, and I think I agree with you. You should have had a conversation with your attorney before we got on the record with a stipulation about dates, because you have a right to have an exam within 21 days of your arraignment, and you were arraigned on this matter on March 9th. So I'm gonna go off the record so that your attorney can go and speak to you, okay?
Thank you.
You're welcome. Did you want to say anything else before she comes down to speak? to you?
Yes. I was hoping that with everything that's going on right now, for a bond reduction or a dismissal, I wanted to talk to my lawyer about it because I don't feel that it's fair or right for me to be sitting in here this long. I'm losing my place. I'm losing everything that I've worked for hard for and sitting in here. And I don't understand why, if the prosecutor had all this time, he had this time, that caseload was in front of him before he even filed the charges. And then after he filed the charges, he's still like, and you still need more time. I just don't understand this. Adjournment is not, no. And then I have to sit in jail for what, 3 more months? Like, can I go home? Can I, I don't understand this, bro. Like, this is my life. We playing with,
I understand, sir. My records, at least in this file, says that you were arraigned on the 9th and bond was issued on the 9th. I'm not sure why you've been in jail for 3 months.
Circuit court.
It sounds like you had an issue before the circuit court and
No,
not this court.
all the only charges I am facing right now is the one that I'm here today on. All
I
other
recognize
charges.
that. Oh, I recognize that's your understanding. I don't know that, but we have not been holding you.
I'm telling you, that's what it is.
He knows he still has a circuit.
I know. I would like.
My understanding is you still have a circuit court case pending, but your attorney is coming down to talk to you now, and then we can make a bond, address bond when you come back on the record, okay, sir?
I'm telling you, I done lost my place already.
Okay, try to calm down, sir, so you can talk to your attorney, and then we'll go back on the record.
Okay.
Okay, can I dismiss Ms. Lloyd?
Yes, sir. I actually wouldn't be able to testify properly on Zoom.
Okay. Okay, thank you. Miss Donnelly is already on her way down to speak to Mr. Thomas. Thank you, in the jail.
Thank you, Your Honor.
You're welcome. And Miss Lloyd, you're free to go.
Am I gonna get a chance to speak on anything?
No, you can't testify because we're not on the record for that purpose. I can't just have you speak.
Well, am I gonna get a
That's why you
chance?
need to be here in
to be
person
able to
to
do
No,
that?
when you come in person, ma'am, you can speak.
Oh, well, I don't have a ride and I'm in Jackson. I'm not gonna be able to make it in person.
There's gonna be I'm assuming a new date. We're gonna have to go back on the record, but I can't just have you come in speaking when you haven't been properly on the record to bring testimony. That's not how the court process works.
I've been trying to get a hold of Adam Pfeiffer. He does not respond. I keep getting a hold of his supervisor. I've been trying to get in contact because I have my stuff. Michael never took my stuff for
Okay,
the
well,
armed
Mr.
robbery.
Pfeiffer's right here. He can step out and give you a call if that's what you want.
Now
Yeah,
that
can
I
you
have a phone
because
number and confirmed that is your
Okay,
email.
he'll give you a phone call.
okay.
Thank you.
Yup.
Okay, we're on the record in the matter of the people of the state of Michigan versus Charles Miles. The file number is 22-01246 FY. Council appearance, please.
Chris Martin for the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Miles, the gentleman who's seated to my right.
Today was the date that was set for preliminary examination. Are you ready to proceed?
Yeah, Your Honor, I'd like to put a few things in the record before we begin.
Okay.
We made an offer to Mr. Miles to resolve this matter with a single guilt, a plea to a single count one of delivery, manufacture of cocaine with a Kilbrew agreement to an 18-month cap on jail time. Obviously, Mr. Palmer would have the opportunity to argue below the cap. He has rejected that offer and will be revoking it at this time.
Go ahead, just a second, Judge.
Absolutely.
I mean, maybe she can almost, free, but they did it almost like a family, and I'd like to see it.
They just let us.
Oh. Okay. Sir, if you'd like to have a seat, you have to stand there.
I thought they were gonna be coming out right away, but.
And of course, now they're walking into the courtroom. So no, just, the judge hasn't come in yet, so.
That was it.
Yeah. Let's do this.
I can't hear you. I can't hear you.
They're not
They're
speaking yet.
probably muted up there. Oh, is that like, oh, that's,
That's, yeah, that's
okay,
me, sorry.
okay. No, it's okay.
Okay, we're back on the record in the matter of the people of the state of Michigan versus Michael Thomas. We went off the record to allow Mr. Thomas to have a conversation privately with his counsel. And how are we proceeding at this time?
Your Honor, at this time, Mr. Thomas would waive Ms. Lloyd's appearance by in person and would have her proceed with the preliminary exam with her appearing by Zoom.
Your Honor, people do not waive such appearance, and given the fact that the people are who subpoenaed Ms. Thomas, our waiver is required for that. Now, I tried calling her. She did not answer my call. Additionally, ethically, I do not believe it is proper to proceed with the examination because now I have, frankly, I have communications that need to be turned over to defense and that are pretty important for defense to have, for Mr. Thomas to have before such an examination begins.
If these are communications that you believe would potentially benefit him,
Yes.
his defense. Okay.
And
I've already released Ms. Lloyd. I wouldn't allow her to proceed in my courtroom virtually because she appears to be a little bit combative and she wants to come off mute and talk when she feels like it. So she's gonna need to be in the court. I tried to explain to her that you can't just talk because I don't have you called here on the record for that purpose during this time. If we're gonna proceed with an exam, that's different. But she does need to appear in person, based even on the email that I got from Ms. Lloyd today. I would imagine that there needs to be some further discovery on that because it appears, for your benefit, Mr. Thomas, there may not be sufficient evidence for the people to proceed. So you would want to grant them a time to flush that out, and then if they don't have sufficient evidence, then they would move to dismiss.
that's the thing, Your Honor. I can proceed with Officer Hutchins today, and I believe get bind over on all of the charges. Ethically, this needs to be looked at first before such an examination happens.
Okay. Mr. Thomas, you had your hand raised, sir?
Yes, Honorable Judge Simmons, I wanted to say, I understand that, it's things that may or may have not come to the light, but due to the amount of time that both parties had to figure things out, I don't think it's fair or just for me to sit in Ingham County Jail for any longer, at least for the amount of bond that I'm sitting in here for. If he has some more evidence that come to the light that's supposed to help my case, why is my bond $50,000? Why am I being treated?
We
Why am I
haven't
being
addressed your-
treated
We haven't addressed your
like
bond.
I'm guilty?
This bond was set before we got this new information, sir. This bond was
I'm
set
innocent until proven
by
guilty,
the
Judge.
magistrate on the night. So this was not a bond that was set when this information went forward. I told you we could address your
understand.
bond. Your attorney can make a bond motion in just a moment, but right now we have to first address the fact that there is some pending discovery or investigation needed to see if the people even have sufficient evidence to move forward in the interest of justice.
Yeah,
And
I would
again,
like my. I'm
okay,
sorry.
if you're just
I
gonna ask me
apologize.
about your
I'm
bond
sorry.
again. Yeah,
I'm sorry.
your
No,
attorney,
I
it's your
wasn't.
attorney's
I
job
wasn't.
to address bond. Okay.
I understand, but if they don't have efficient evidence, then I would like my attorney to file for a dismissal without prejudice. And then they can bring this up again in a later time. Why do I have to sit in jail?
Okay,
And
as
be
of right
treated-
now,
and
I don't
be-
think you understand the process because again, if we proceeded right now, what Mr. Pfeiffer is indicating, he has an officer here that could put on enough evidence to satisfy probable cause. That's not in your favor, sir. Especially if there's a witness that is saying that there may be some evidence that would exonerate you. You're gonna wanna give them the opportunity to look through that and see if you can be exonerated. Because if we move forward today and he has a witness here who could testify, then your case is likely to get bound over, and then you're still waiting to go to the circuit court. So I don't think that's in your best interest, sir.
But I don't want to sit in. I had a housing voucher through Lansing Housing Commission since I was 19, and I lost it because I was sitting there.
I understand your concern. Is it
You
your
know?
concern? I understand your concern. We're gonna address your bond in a moment, sir, okay?
Okay, and my lawyer is calling me out my name and stuff, and I don't even like, bro. She called me a maniac, so I don't know. What did you say? Lunatic, maniac? What did you call me? Like, this is like ridiculous.
Your Honor.
She calling me out my name.
At this point-
She's not being professional. She's not being professional.
Mr. Thomas, you wanna protect our,
Yeah, you have an attorney-client relationship, so I don't want you to say or tell me what you are talking about in public. If you do have a concern about your representation, sir, that's different. You can address that if you don't feel like you're getting effective assistance of counsel. But I don't want you to disclose your private communications, okay?
Okay,
Your Honor.
all right.
Frankly, he did just nullify the attorney-client privilege when it comes to if Ms. Donnelly did in fact call him a lunatic. Based on his behavior today, I'm frankly concerned about his competency. He seems to not even be aware that he has 2 circuit court cases with the same victim.
They're still pending now.
They're live now, and he's been
I
insisting that
asked-
he doesn't have them.
Mr.
I
Thomas,
asked
do you
him-
know that you have other matters pending before the circuit court right now?
I was notified by Ingham County Jail that I'm not being held on any other charge but the charge that I'm facing today. I was notified that Honorable Judge, what's her name?
He's gonna appear about the judge.
Honorable Judge Aquilina dismissed those charges. That's what I was told from the jail. That the only
Sir,
thing
that
I'm
is
being
not-
held on is,
That's,
huh?
did you go before Aquilina and she tell you dismissal, or did you receive a copy of a nollie stating your case was dismissed?
I had, the courts told me, the jail told me.
This is what I'm talking about. These are my cases, Your Honor. I know them forwards and backwards. No, they are not dismissed.
Okay, the prosecutor is assured that your cases are not dismissed and that they are pending. The jail can't tell you that the cases was dismissed. The court has to let you know that they've been dismissed.
I'm not
Who's your
being
attorney on
held
those
on.
matters? Are the cases
Yeah, and I
dismissed?
had, this the first
Okay, your cases are
first
not
time I
dismissed. Your
even spoke
attorneys,
to them.
your attorneys are also saying the cases are not dismissed. I agree that there may be an issue with competency.
I'm not his attorney, but frankly, I'm concerned about his ability to make an assistant legal decision for himself.
Okay.
If he's not understanding what his situation is. And so understanding what his situation is.
Okay, I think that, sir, based on this, we may need this petition to have you evaluated for some competency, because for you to not understand what I'm explaining to you and also what your
I
attorneys have explained to you.
understand what you're explaining to me, Judge. What I'm saying is, if I'm not being held on these charges, and these charges have nothing to do with this case, I don't understand. I asked the court, the jail every day, what am I being held on? If y'all keep bringing these charges up on a matter that have nothing to do with this caseload, why is my bond 50,000? When I got
I'm not
arraigned by
sure
the
what you're talking
magistrate.
about, sir. I'm sorry, I'm not able to follow what you're saying because we've not brought anything else up. I haven't. All I have before me, and this is the first time I've ever laid hands and eyes on this particular case. I was not the person who arraigned you. We got an email from the parties at your probable cause conference that it was continuing to exam because one of your attorneys has a conflict. But I would not have even been aware that you had other matters pending, but for the fact that you mentioned it today.
To be fair, Your Honor, it was going to be an element of the case in regards to identification because there was no contact orders in place from the previous cases during this case.
Okay, so again, if the attorneys want to submit a petition for competency, I will review and sign it. I think I've seen enough today to order him to have a evaluation.
But Judge, Honorable Judge, I understand everything that's going on.
Okay, that's good. That's what we want you to do, but we want you to also be able to assist in your defense. And so we need to make sure you're able to do that. I'm also going to find good cause to waive the 21 days based on the proceedings today. And I'll get you a new date for your examination today. And then if your attorney wants to address bond, she can do so.
Can we address bond?
Yes, Your Honor, thank you. So yes, Mr. Thomas, it's currently set at 50,000 cash surety. I don't know if that is with also a GPS tether, but what Mr. Thomas would request is obviously a lower cash bond because he can't post the 50,000. And I would suggest if there isn't a GPS tether, that would be a nice compromise. Make sure the court knows where he is with the exclusion zones.
Based off what Officer Hutchins told me today, it appears to link the victim, Michaela Lloyd, to the individual named Kayla Hott that he has been video messaging with consistently from jail across all three cases. And that's something else that I'm going to have my detective be looking at. Besides the video visits, there have been hundreds of calls to that person.
Okay, is the allegation that he was on bond during this incident? I'm not following.
He was on bond during this incident, not supposed to be around Michaela Lloyd. But additionally, while waiting for this case, he had been video chatting, apparently with Michaela Lloyd from the jail. My officer confirmed that it is the exact same location, couch, TV, child, everything from when she went and talked with Michaela Lloyd that is in these video visits.
Okay,
So I think he's gonna go right back to her if he's let out. As a matter of fact.
That's
GPS
not
does.
true.
GPS
That's not
just tells
true.
us after the fact.
okay, we have
That's
one,
not
we have
true.
one count. We have one count of attempted armed robbery or unarmed robbery, I'm sorry. And then a larceny in a building as well as a domestic violence.
And none of them is true. None of the such things is accurate.
I would entertain a reduction. I'm not gonna personal or PR him. I don't believe that he's presented to the court in a condition that would make me feel like he would return on his own personal recognizance. But I will reduce the bond to 25,000 cash surety.
What is that?
And there was already GPS tether
With
with
victim
victim
notification.
exclusion zones ordered at the original arraignment. That will continue.
Your Honor,
Yes, sir.
may I ask, so how much would that be? 25,000? Is that 10%? Like, what is that?
No, I said cash shorty, so you need to call a bondsman. And they'll tell you what the fee would be, okay? Any additional matters for the, oh, let me get your date.
Yes, please.
June 23rd at 9 a.m. will be the new date for exam. Any additional matters for the record?
Not from
Can
the
I,
people, Your
can
Honor.
I say one more thing?
Yes, you can.
Can I get a different representative, a different lawyer?
Okay, are you on this?
Because
or
I
is
don't
it-
think
It's
that, I don't
Petrovich.
think
Next
that.
time you will have Petrovich.
Okay, your actual attorney is Petrovich, so Ms.
Okay,
Donnelly is not your attorney.
I don't think Sarah or Charlie Prefovich has my best interest.
Well, Mr. Petrovich
At
is
all?
not here, so.
I understand that, but I
Have you
spoke to him
spoken
on
with
the
him?
18th. Yes, I have, on the 18th.
Okay.
And he was questioning me about me being a twin.
Okay, I don't wanna know what your attorney was, that's private.
Okay,
That's
okay,
privileged
okay,
communication.
I understand that. Okay, I understand that, but I
okay,
still
then
don't
we're gonna
think that he
stop.
has my
I gotta
best
stop you,
interest.
sir. I gotta stop because you're gonna tell me some stuff that you shouldn't be telling me, and so I have to jump in and protect your rights, okay?
So I can't
But
get a
Ms.
new
Donnelly
lawyer.
is not your attorney, Mr. Petrovich
I
is.
don't-
When he
I
comes
don't want
back,
him either.
okay, I recognize that. You can file a motion because you can't go picking or shopping which attorneys out of the public defender's office you want to represent you, okay? You don't get to do that. You also have the right to hire your own attorney if you're not satisfied with the attorneys from the public defender's office, but I don't have the right to choose who represents you from the public defender's office either. Okay, we're off the record. Thank you.
Your Honor.
So 25.
Okay, we're on the record in the matter of the people of the state of Michigan versus Andre Kelly, file number 22-00986. Council appearance.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Kelly, who is present and standing to my right.
Thank you. And today's the date set for a preliminary examination. How are you today? Okay. Let's see, I'm doing well. Hopefully we'll continue on that vein. What are we doing on this one?
Your Honor, it's my understanding that at this time, both the people and the defendant are going to unconditionally waive their rights to preliminary examination, and we ask this case be bound over to circuit court at this time.
Okay, Mr. Nichols.
That is correct. And at this time, it's my understanding that people have made an offer to Mr. Kelly that in exchange for a plea to count 1, the people would be willing to dismiss count 2.
That's correct. Your Honor.
We would like the matter bound over, and negotiations will continue in circuit court.
Okay, and so Mr. Kelly, you understand that you have the right to have a preliminary examination here in the district court?
Yes, sir.
You understand that during that examination, you have the right to have the prosecution establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you as the defendant that committed the crime?
Yes, sir.
You want to unconditionally waive your exam?
Yes, sir.
Okay, so that means you can't come back later and say you want your exam. Once you waive it, it's gone. There won't be a hearing at this stage in the district court to determine sufficient probable cause. You understand that?
Yes, sir.
Is anybody making any promises to you to get you to waive your examination? Is anybody threatening you at all? Are you waiving it freely and voluntarily? Okay, the matter will be bound over to the circuit court. Your bind over date is June 8th. You do not need to appear in court on June 8th. That's just the date they'll get the file from this court. You will not have arraignment in circuit court unless Mr. Nichols files a motion requesting one, okay? Do you have any questions at this time? Bond was set at 5,000 personal recognizance. It will continue. Any additional matters for the record?
Nothing for the people.
Nothing from the defense, Your Honor.
Thank you. You're all set, sir.
Oh, yeah. You want him to sign it too?
All right.
When we get-
Yes.
I must be missing some files. Oh, these are at one. Got it. We're going back on Miles now. Okay, we are back on the record in the matter of the people of the state of Michigan versus Charles Miles. We went off the record so that Mr. Palmer can have a private off the record conversation with Mr. Miles. Prior to going off the record, there was an offer indicated on the record that the defendant had the offer to plead guilty to count one with a killable of, what was the killable again?
18-month cap.
18-month cap, and that offer would be withdrawn if we proceed with the exam. Is that correct? Okay, Mr. Palmer, how we proceed?
Thank you, Your Honor. I've had an opportunity to speak with my client. After discussions, he still desires to proceed to preliminary examination. We're prepared to do that today. The only other matter I'll ask I'll ask prosecution to confirm this. I'll ask Mr. Martin to confirm this, but count 4, I believe, will be dismissed today and will not be proceeding on the exam.
Mr. Martin.
Correct. Moving forward on counts 1, 2, 3, contact 4. And that was also communicated to Mr. Palmer.
Any other preliminary matters?
Call Trooper Jacob Fairchild.
you solemnly swear or affirm the testimony you're going to give is true to the best of your knowledge, information, or belief?
I do.
Thank you, sir. You can have a seat there. Okay, and Trooper, can you state your first and last name and spell them both?
Yep, Jacob Fairchild, JACOB AIRCHILD.
You can proceed, counsel.
Before we begin, Your Honor, may I ask if we're live streaming this?
We are live streaming.
Would it be possible to move the camera so that the Trooper Fairchild's not on the screen? Thank you, Your Honor. Trooper Fairchild, how are you employed?
I'm employed with the Mission State Police.
And what is your current role with the Mission State Police?
I'm assigned to the Tri-County Metro Narcotics team.
Is that the Tri-County Metro Narcotics Task Force?
Yes,
What does the Tri-County Metro Narcotics Task Force do?
we investigate and enforce violations of the Controlled Substance Act.
And in that role, do you often serve in an undercover capacity?
I do.
And when you're serving in an undercover capacity, what type of work does that require?
It requires us to communicate with people, purchase narcotics from them. And things of that nature.
And when you say communicate with people, are these people who are suspected to be involved in the drug trade?
Yes, sir.
And you often conduct undercover purchases.
I do.
How long have you been assigned to the Tri-County Metro Narcotics Task Force?
About 2.5 years.
And so you were assigned to the Tri-County Metro Narcotics Task Force on April 19th, 2022.
Yes, I was.
I'm gonna ask you some questions about some transactions that you took part in. And these involve a suspect named Charles Dwayne Miles. Does that name ring a bell to you?
It does.
And if you saw have you seen Mr. Miles in person before?
I have.
Can you say the circumstances under which you've seen him in person?
I've purchased narcotics from them on multiple occasions.
All right, do you see Mr. Miles in the courtroom today?
I do.
Can you please point to him and identify an article of clothing he is wearing for the record?
Sitting next to his defense attorney wearing a dark blue swimsuit.
Your Honor, may the record reflect that the witness identified the defendant?
Any objection to identification?
Not for the purposes of exam.
Identifications? No, thank you.
Did you come into contact with Mr. Miles on April 19th, 2022?
I did.
Do you recall where you came into contact with him?
Would have been near the intersection of Martin Luther King and Mount Hope.
And that's in the city of Lansing, Ingham County, Michigan?
Yep.
What happened when you came into contact with him at that location?
Pulled into a parking lot of a liquor store located at that corner. Mr. Miles jumped into the front passenger seat of my vehicle. Handed me suspected crack cocaine in return for some pretty metro funds and exited the vehicle.
Okay, and after that transaction took place, did you have an opportunity to examine the suspected crack cocaine you had purchased?
I did.
And were you able to test that cocaine?
I was.
And can you say a bit about what the device you used to test suspected crack cocaine is?
It's called a TrueNarc scanner.
Okay, have you been trained in using a TrueNarc scanner?
I have.
When you use a TrueNarc scanner, what's the first thing you do?
You check the device. It was a self-check.
All right, and then after that self-check, what do you do next?
Then you test the substance.
Okay, and then when you test the substance, does it have a screen that shows you what the substance is?
Yes.
Okay, and then what do you do after you test the substance?
You check the device again.
So I want to talk about the substance you acquired on April 19th, 2022. Did you use your TrueNarc scanner to check that substance?
I did.
Did you conduct the self-check?
Yes,
Did it appear to be functioning correctly?
it was.
After that, what did you do?
I tested the substance.
And after you tested the substance, what did the machine display?
Displayed cocaine base, which shows like a substance of crack cocaine.
And you know from your trading experience, that means it's cocaine.
Yep.
Did you do the third step, the second self-check?
I did.
And again, the machine was functioning properly.
Yes.
So based on that, you believe that on 4/19, the substance you purchased from Mr. Miles was crack.
Yes.
Talk about something that happened on April 25th, 2022. Did you come into contact with Mr. Miles on that date?
I did.
And where did you come into contact with Mr. Miles?
It was near the intersection of Washington and Mount Hope in the city of Lansing.
Can you say what happened when you came into contact with him?
pulled into the parking lot of the liquor store located at that corner. Mr. Miles jumped into the front passenger seat of my vehicle and sold me some crack cocaine in exchange for pre-recorded metro funds.
Okay, and after you exited that situation, did you have an opportunity to examine the crack cocaine?
I did.
Did you test it?
Yes,
Did you use the TrueNarc scanner to test it?
I did.
Beginning with the self-check,
Yes,
does the machine appear to be functioning properly?
it was.
Did you test the substance?
Yes.
What did you find?
Came back as base.
You did the third step,
Yes,
the machine still functioning properly?
it was.
Based on that interaction, you believe that you purchased crack cocaine from Mr. Miles on April 25th, 2022.
Yes, sir.
Going to direct your attention to some things that happened on May 2nd, 22. Do you remember that date?
I do.
Did you come into contact with Mr. Miles on that?
I did.
Where did you come into contact with Mr. Miles?
Again, near the intersection of Washington, Humboldt, and City of Winston.
Same location as the prior
Yes.
deal on the 25th?
Yep.
What happened on the 2nd of May?
I pulled into the parking lot of the liquor store located near that intersection. Some Miles jumped into the front passenger seat of my vehicle. Handed me some suspected crack cocaine. for metro funds.
Okay, did you have a chance to examine the crack cocaine that you purchased on that day?
I did.
And did you use your TrueNarc scanning device to test it?
Yes, sir.
Did you do the self-check?
Yes,
Did it appear to function properly?
it was.
Did you test the substance itself?
Yep.
What did you find?
Came back as cocaine base.
And then the third step,
I checked.
and it was functioning properly
It
still.
was.
So based on that, you believe you purchased crack cocaine on May 2nd, 2022 from Mr. Miles.
Yes, sir.
And that's the same Mr. Miles you identified earlier on all three occasions.
Yes, sir.
People. Sorry, no further questions.
Francis Hammond.
Thank you. Morning, Trooper.
Morning, sir.
Some questions about this. So the first buy that you testified to this morning was occurred on April 19th, is that right?
Yes, sir.
Prior to April 19th, have you ever met Mr. Miles before?
I did not.
Prior to April 19th, have you ever spoken to Mr. Miles before?
No.
Have you ever seen him before that date?
Prior to the 19th? Yes. No.
How is it, and you wrote a report in this matter, is that right?
I did.
And everything you placed in your report is fair and accurate to the best of your recollection?
Yes.
Did you review your report in preparation for your testimony today?
I did not review it today, but I have reviewed it. Yes.
Okay, and there's nothing that, in your review, there's nothing in there that's factually inaccurate, is that correct?
That
As
is
far
correct.
as far as you recall?
Yeah, that's correct.
So in your report, you indicate that on April 19th, that you contacted a telephone number. So in other words, you reached out to Mr. Miles, is that right?
I did.
And this is a gentleman that you've never met before, never spoken to, never seen before. Is that right?
Never in person, correct.
Never in person. How is it that you came into contact or that you made the decision to reach out to Mr. Miles on that date to ask this person that you've never met before that if he could sell you cocaine?
I was provided his telephone number from another detective.
And do you know anything about that investigation?
I do not.
You don't know anything about the investigation whatsoever?
Prior to my contact with them?
That's correct.
Correct.
You don't know how, it's your testimony that you don't know how other detectives from your unit came to be investigating Mr. Miles?
It was not a detective from my unit. It was a detective from another unit
All right,
who gave me the number.
Do you
And
know
I'm
what-
not aware of any investigation that they had into Mr. Miles prior to my contact with him.
all right. So as far as you know, your personal knowledge at least, you were just handed this telephone number, you call it up and ask whoever answers that phone if he could sell you crack cocaine.
I was given the phone number. I was advised that it belonged to Charles Miles. And I was told that he's a drug dealer. That's what I was told. So
Any other information besides the name and the fact that the guy you're calling is a drug dealer?
I was given his name, his phone number, and his criminal history.
In his criminal history. You don't have any personal knowledge as to whether there was even investigation going on, is that right?
I have no idea.
So you don't know whether his name came in from a confidential informant?
I would object to the extent where the question calls for hearsay, the answer would call for hearsay, or the unmasking of a confidential informant.
Is you want to respond to the objection?
Well, Judge, I would respond to the objection in that two things. One, I'm not asking him for what was said. I'm asking him if he has personal knowledge of how Mr. Miles came under investigation. Also, I did not ask for the name of the confidential informant. I just asked if it was a confidential informant who was the individual who originally took off this investigation.
And I would agree that he can testify to his knowledge, but to the extent somebody told him something else, I think it does get into the hearsay realm. So I would just, it was a sort of cautionary objection.
I understand that objection. Mr. Martin is absolutely correct that if this officer testified as to what someone else said, that would be hearsay and would be improper. That, to the extent that my question was calling for that, that was not my intention.
Okay, I don't know if you want to try to rephrase.
I can
your
try to
question.
rein that in.
Okay, the objection sustained.
Sir, do you have any personal knowledge? And again, obviously, as you've heard, I'm not asking what was said. Do you have any personal knowledge of how it is that the investigation came to focus on Mr. Miles?
No, I did not ask.
Is it common for you to not ask?
In some cases.
In some cases. And when you say in some cases, what would be the difference to whether you would ask or not?
The detective that provided me his phone number is not someone that I work with on a daily basis, is not in my unit.
Okay.
Okay, so in that instance, it's not uncommon for me to not get all the details of how they came into contact with them.
All right. Any idea as to why it was you that was asked to be if this is not coming from your unit, do you have any idea as to why it was you that was asked to be the detective, or excuse me, the officer who's going to do this control?
What was required was for someone to be willing to conduct a control purchase themselves.
Any idea, well, let me ask you this way. Was this the first controlled buy you'd ever been a part of?
No.
So you call him up, you arranged to meet him, is that right?
Yep.
And you called him up and met him the same day?
Yes. Yeah, the first day that I called him was the first day that I met him.
Okay. And do you know how long it was, if you recall, between the time you called him and the time you met him?
I couldn't tell you the exact time, but it would have been within a few hours.
Now, you indicated in your report that you used pre-marked funds, is that right? Pre-recorded funds, I guess is the way it's said.
Yes, sir.
All right. What is the purpose of using pre-recorded funds?
So that way, essentially, I give him the money in exchange for the narcotics. Right?
Okay.
Later on down the line, when we go to arrest the subject, if he has money on him, we can, compare the money that he has on him to money that we've used in prior control purchases.
Okay. Did you ever, so you used pre-recorded funds on April 19th, right?
Yes.
Did you ever record it, or excuse me, did you or your team, at least to your knowledge, ever recover any of the pre-recorded funds used in the April 19th buy?
No, we did not. Not to my knowledge.
The buy was made on April 19th. The buy was completed, is that right? On that same day. In other words, the money was exchanged for what you believe to be narcotics on that day.
Yes.
Right? It wasn't meant to be a trick question. There was no like, I owe you,
Yeah.
Here's some of the money and I'll get the rest later or something like that. Right?
Yeah, no.
And at that point, well, let me ask you about, on that day, you arrived at the meet spot with Mr. Miles, correct?
Correct.
Were there other officers there?
There was.
All right. Do you know how many?
If I looked at the report, I could have refreshed my memory.
I would object to the relevance of this question.
All right. Well, let me rephrase it. Do you know if anything about this purchase was recorded?
In what fashion?
Either audio or video recorded?
Not that I have access to, no.
Nothing you have access to. Does that mean that someone else may have recorded it?
No. All right. There is no video or audio recording of any of the control purchases.
Okay. That's what I was getting at. All right. So if the transaction is completed at that point, and he, at least according to your testimony, he makes a sale of narcotics, that's a crime, correct?
Correct.
Why not arrest him at that?
To further the investigation.
So to further the investigation, you made an additional sale on April 25th, is that right?
Additional purchase, yes.
Or, sorry, an additional purchase on April 25th.
Yeah.
And again, that one was made using the pre-recorded funds.
Yes.
Were those pre-recorded funds ever collected?
No. There were none of the pre-recorded Metro funds were recovered from anything.
From any of the control purchases? Were you ever involved in searching Mr. Miles' house?
Yes.
What, if anything, did you find at the house?
I recall what we seized from the house, but there was no other narcotics that were seized.
All right,
Or
so
no currency either.
all right, so no suspicious amounts of currency are seized at the house, right?
Correct.
And I guess to be clear, you didn't recover any of the pre-recorded funds from any of the buys at the house,
Correct.
and didn't find any narcotics in the house either, right?
Correct.
Did he also volunteer to turn over his cell phone to you?
Not to me.
Not to you.
I didn't conduct any interview with him
Okay,
after he was taken into custody.
all right. So I guess my question, and you may not be an individual who can answer this, but my question is, if the crime was committed on April 19th, what was it that you thought needed more investigation to continue making controlled buys from him, as opposed to just arresting him on the controlled buy of April 19th?
You asked the question one more time.
Yeah, that's fair. So it's your testimony here that it's, at least as far as you understand it, a controlled buy was made and completed on April 19th, right?
Yes.
And that controlled buy, as far as you understand it at least, is a crime, correct?
Correct.
But you indicated that you didn't make an arrest, or no one made an arrest on April 19th because there was a need to further the investigation. Is that right?
Correct.
What is it that needed to be furthered once the crime is complete? What further investigation is necessary at that point?
There's still many variables to that point.
Okay.
It's one control purchase.
All right.
Further the investigation to know more about the subject.
And so, well, let me ask you this. What is it that what more do you need to know about? You know his name, right?
Yep. Habits, pattern of life.
Are his habits and pattern of life relevant to the crime?
It is, it would be indicative of whether or not there's a stash house or something of that nature.
Okay. So you make a second control buy 6 days later, right?
Correct.
All right. And at that point, are you doing anything in terms of surveillance or observation or contact with Mr. Miles, or anything in terms of the investigation between April 19th and April 25th that furthers the investigation with regards to, say, a stash house?
Are you asking if prior to the second control purchases there was surveillance conducted on them?
Yes.
Not that I would be a part of.
So you have no knowledge. Is that right?
Correct.
And then there's an additional period, roughly another week or so, between April 25th and May 2nd. You did not arrest after the April 25th incident, is that right?
Is that the second control purchase?
That's the second control. Correct. All right. And you didn't arrest after that incident because there's still a need for further investigation?
Yes.
Just one question. You said that the first purchase happened at Martin Luther King at Mount Hope.
Correct.
And then the second and third purchases were at Washington at Mount Hope.
Correct.
And that intersection of Washington and Mount Hope is in the city of Lansing.
Yes.
Yes. No further.
Thank you. May this witness be excused?
Yes, Your Honor.
Okay, thank you, Detective.
Hang on. You want to? But you can actually just stay here if you want.
Okay. Any additional witnesses?
The people restroom.
Any defense witnesses today?
No, Your Honor. Thank you.
Okay. We can proceed to argument.
We asked for bind over on the complaints On counts 1, 2, and 3, as we've indicated earlier, we're not proceeding on count 4.
Okay. Any counter argument?
Judge, I would ask that the matter be dismissed for lack of probable cause. I realize that that's a low standard, so I will leave my argument there. I do have some concerns about the methods in which the investigation was advised and not went through, but I don't know if those are properly before this court.
Yeah, today is the date set for preliminary examination, and the burden is on the prosecution only to establish probable cause, which is just a standard of more than just mere suspicion. So I think the other concerns that you may have are appropriately addressed at the circuit court level. I have testimony here of an incident that occurred on April 19, 2022 at the area of MLK and Mount Hope, City of Lansing, Ingham County, State of Michigan, making venue before this court appropriate. The suspect was identified as the defendant, who sits in the court by the name of Charles Dwayne Miles. The detective testified that he made contact with Mr. Miles, met with him at that date and time in that location in a parking lot near a liquor store, and that they conducted a controlled narcotics purchase for the suspected cocaine, which he true narc tested when it came back as the substance with a base of cocaine. He testified as to an incident that occurred on April 25th, 2022 in the area of Washington and Mount Hope in the City of Lansing, Ingham County. Similar situation, he pulled into a liquor store parking lot. The person he identified as the defendant, he said, jumped into the passenger seat and sold him suspected cocaine, which he true narc tested later, and it came back as a cocaine base. He also testified as to an incident that occurred on May 2nd, 2022, the area of Washington and Mount Hope. Again, similar situation. The defendant, or the person he identified as the defendant, jumped into the front seat, sold the detective suspected cocaine, which was later true narc tested as substance containing a cocaine base. That's more than sufficient probable cause. It meets the standard, so this matter will be bound over, or these matters, counts 1, 2, and 3, will be bound over to the circuit court. Count 4 is dismissed by motion of the prosecution. The bind over date will be June 8th. You do not need to appear in court on June 8th. That's just the date that they get the file from this court. Your next court date will be a pretrial in circuit court. Your attorney will be made aware of that court date. Okay, Mr. Miles?
Yes, ma'am.
Judge, could we also address bond?
Okay, just a moment. Okay, yes, you can address bond.
Thank you, Your Honor. I would ask that the court consider adjusting Mr. Miles's bond. His bond is currently set at $25,000 in cash. He's in the Ingham County Jail. Your Honor, he has a stable residence here in Lansing. I don't believe he's ever failed to appear for court before when ordered to do so. I don't believe him to be a flight risk. I would also suggest that any flight concerns that the court would have, I don't think they would be significant, but if they had some, certainly those could be cured with something like a GPS tether. Your Honor, he's got some sick family members that he would like to get out and help care for and visit. I certainly believe that Mr. Miles would intend to return to court. We will continue to pursue this matter on his behalf. I would ask that the court consider, not a personal recognizance bond, I would ask the court consider just changing that from cash to a 10% bond. I think that would be appropriate. Mr. Miles, I think 25,000 cash is just a significant hurdle for him to even come close to, but I think 10% would get him in the realm of maybe be in the post. So I'd ask that the court consider a bond ultimately.
Mr. Martin.
We leave it to the court's discretion, Your Honor.
Okay. Mr. Miles, have you missed court before?
No, ma'am.
He doesn't have anything else pending?
Not that I'm aware of. Like, he does have a criminal history, but I don't believe he has anything else pending this time.
Any assaulted criminal history?
Judge, I don't believe so.
Oh.
A
Grant
lot
the
of,
request.
I'm sorry, I didn't mean to interrupt.
Fine, I'll grant the request for a reduction in bond with GPS tethering. The bond will be reduced. It looks like I reduced it before 25,000 cash surety. That's what you're asking me to reduce to 10%.
I'm asking you that
Or
now that,
PR.
yes, Your Honor, I'm asking that now that preliminary examination has been held, I'd ask the court to consider.
I will reduce it to a 25,000, 10% with GPS tether. You do. Or you, if you don't, you could apply for assistance. They do have applications if you're indigent, okay? Any other questions?
Nothing on this file, Your Honor.
I have nothing further, Your Honor. Thank you.
You're all set, sir.
Your Honor, may we approach to introduce you to our summer intern?
Yeah, you can. Okay. On the record in the matter of the people of the state of Michigan versus Mark Grove, file number 22-00854 FY, council appearance.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Scott Nickel appearing on behalf of Mr. Grove, who is present and seated to my right.
Thank you. Today's the date that was set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
Nothing from the people.
Nothing from the defense, Your Honor.
You can call your first witness.
Thank you, Your Honor. For their first witness, people will call to stand Trooper Daryl Myers. Yeah, go ahead.
You solemnly swear or affirm the information you're going to provide is true to the best of your knowledge, information, or belief.
Yes.
Thank you, sir. You can have a seat. Yes. Sorry, it's tight. Um, Not at all. Can you please state your first and last name and spell them both?
Daryl Myers, DARYLMY.
Proceed, counsel.
Thank you. Trooper Myers, can you please state your occupation for the record?
Yep. Officer with the Michigan State Police,
And how long have you been employed by the Michigan State Police?
approximately 9.
Trooper Myers, I'm gonna take you back to March 25th of 2022. Do you remember that date?
Yes.
Were you working in your capacity as a police officer on that date?
Yes.
And were you working for MSP on that date?
Yes.
Were you working alone or with a partner?
Hello.
And were you in a fully marked car on that date?
I was.
Okay. And what type of uniform were you wearing?
Single out.
Was that a patrol uniform?
Yes.
Now, on that date, were you present in the area of Miller and Winterset in the city of Lansing and county of Ingham?
Yes.
Okay, and is there anything specific located at that address?
It's just a neighborhood houses.
Okay.
What I recall.
And how is it that you came to be at that location?
I was just patrolling, heading towards my home.
Okay, and what, did something catch your eye while you were driving?
Yes, a vehicle in front of me come on.
Okay, and what was it that caught your eye?
Numerous violations on it. I was working the area for the day, actually looking for some vehicles, and I know there was at that time a vehicle, not this one, but one like it. So I ran the plate on it to make sure it was not that. So
Okay, and when you ran the plate on it, were you alerted to anything specific?
I was alerted to the register owner who was had a warrant for his arrest for parole.
Okay, and were you able to observe that person?
Yes.
Okay. And when you looked up the information, the computer, did it have a photograph of the person that was the registered owner?
It did not have a photograph, it just had a listing of his description along with the numerous tattoo marks.
Okay. And did you observe this person to be in that vehicle? Okay. And at that point, what did you do?
I performed a traffic stop on the vehicle, placed the driver in custody.
And after you placed that driver in custody, what did you do next?
I then tried to identify the other people in the vehicle.
Okay. And can you tell us who all was in the vehicle, if you remember?
I do not.
Can you tell us if it was,
I know it was 2 females, 2 males.
okay. And was one of the people aside from the person that was placed under arrest immediately in the courtroom today?
Yes.
Hey, can you please point to that person and describe something they're wearing for the court? Can you describe something that he's wearing?
Oh, he's wearing a black t-shirt. and his glasses on.
Thank you. Your Honor, please let the record reflect that the witness has identified the defendant.
No objection for the purposes of preliminary.
Identification is noted.
And Trooper Myers, at any point were you able to determine who those three people in the vehicle were?
Yes, I was.
Okay, and you indicated also that Mr. Grove was one of those people, correct? How are you able to identify him on the scene?
So I identified him, Mr. Grove, because he did not have a photo identification on him. I used my issued fingerprint scanner.
Okay. And when you identified him by that fingerprint scanner, what did you do next?
I then ran all the individuals in the meeting to see if there were any warrants.
Okay, and that included Mr. Grove, correct?
Yes.
And at the time, did he have any active warrants?
Yes, he did.
Okay. And at that time, were you also able to access his criminal history
I accessed the criminal history
later on?
Yes.
And it was still through lien though?
Yeah, so there's.
Okay. I'm gonna just walk you through that now, just to make. Let me get it out.
Okay.
You were able to identify his criminal history, correct?
Yeah.
Okay. And were you able to determine whether or not he had ever been convicted of a felony?
Yes.
Okay. And do you remember what that felony was?
I do not recall. I do know that he was convicted, and that's all. I remember.
Do you remember approximately what year he was convicted of a felony?
I have to know. I've
Okay.
run numerous sieges. I just don't keep track of that stuff.
Okay. Do you know where that conviction was out of?
Again, I have to know. I apologize.
Okay.
I know it's state of Michigan.
And in addition to that, did Mr. Grove indicate to you in any fashion that he was in fact a convicted felon?
During the traffic stop.
Yeah.
Yes, at the point when I found body armor and asked him about it and asked about being, I don't exactly recall the conversation, but I was something along the lines of, aren't you convicted felon? Are you supposed to have body armor? Like,
Okay. Now I'm gonna take you back to where you get the identification of Mr. Grove. What did you do after that identification? Of Mr. Grove and the other people in the vehicle?
I asked documents, exit vehicle, perform the search of the vehicle.
And did you find anything while you were doing a search of the vehicle?
The biggest thing I found was the safe.
And also for the search of the vehicle, did you have consent from the owner to do that? Now, prior to the safe, did you find anything else in there that caught your eye?
I can't recall. The only thing I do recall is when I pulled first the driver out of the vehicle, while putting in cuffs, I noticed track marks on the arms.
Okay.
That's all I recall.
Okay. And you mentioned something about body armor. Was that also present in the vehicle?
Yes, it was.
Okay, and where did you find that body armor?
That was in a bag in the back seat, directly below the seat.
And were you able to determine who was the owner of that bag and the body armor?
Yes.
And who did you determine it belonged to?
Mr. Grove.
Here, I'm going to show what's in Marcus Siegel's proposed exhibit number 1 to defense counsel. And permission to approach, Your Honor.
You may.
Trooper Myers, can you just take a look at people's proposed exhibit number 1 and let me know if you recognize that photo.
Yeah.
Okay, and how do you recognize that?
That is from my body cam.
Okay, and what is depicted in that?
That is body armor.
And would you say that that is a an accurate depiction of the body armor in the fashion in which you found it?
Yes.
Okay, and as captured by your body camera, correct? Your Honor, I'd ask that be admitted as people's exhibit number 1.
Any objection?
No objection.
People's exhibit 1 is admitted.
Thank you. All right, and you mentioned the safe, so let's talk about that. Where was the safe located?
Safe was located in the back seat. More on the driver's side, behind the driver.
Okay, and what did, sorry,
There's a bunch of items over, and I remember the 2 passengers in the back seat were scrunched up next to each other, so it was kind of in the back, kind of close to the middle.
okay,
It was tight back there.
and what did you do when you saw the safe?
I asked individuals who's this, does the safe.
And were they forthcoming with that information the first time you asked?
No.
Okay, and what did you do as a result of that?
I pulled the safe out. At one point, I realized that there were 2 holes in the back of the safe, because this is a safe that belongs on a wall, usually seen like in hotels.
Okay,
From my previous experience. And the safe, I was able to look into the safe, and I could see some items in the safe.
okay, so I'm gonna show, Your Honor, what's been marked as people's proposed exhibits 2 and 3 to defense counsel and permission to approach a witness.
You may.
Trooper Meyer, same thing as photo number 1, or exhibit number 1. Can you please look at both of those proposed exhibits and let us know if you recognize them? And how do you recognize them?
Because this is from the safe that I found in the traffic stop, and this is the one from my body camera.
Okay, and would you say that both of those pictures accurately depict the safe and the holes that you're specifically referencing?
Yes.
Your Honor, I'd ask that these be admitted.
Any objection?
No,
Thank you.
no objection, Your Honor.
People's 2 and 3 are admitted.
Yeah. And you said you were able to view the contents of the safe through those holes, is that correct?
Yes, partial contact, enough to make out a gun, a grip of a pistol, of a gun, and a box of ammunition.
Okay. And at this point, or once you realized that you had seen something that you recognized to be the grip of a pistol as well as a box of ammunition, what did you do next?
I then asked for a canine dog gun on scene
Okay,
to sniff the safe.
okay. Were you concerned for your safety at that point?
Yes.
Okay. And what happened next?
The dog alerted.
Okay.
To the presence of narcotics.
And at the time that you had reached out for the canine, you were not aware or you were not able to see any narcotics inside that safe, is that
That's
correct? Okay. And what did you do after the dog alerted to the safe?
Then we opened the safe up.
And how are you able to open the safe?
I believe I used a crowbar. Some crowbar size, whatever tool I had in my vehicle.
So tools in your vehicle? Okay. And are you able to get into that safe?
Yes.
Okay. And what was in the safe when you opened it?
There were 2 pistols. There was some ammunition. There were some documents. There was some methamphetamine.
Okay.
I believe a scale. And there might have been a ball. I don't think I put that in the report.
Okay. I'm not gonna talk about the ball cap. That's not illegal.
Right.
Now you did mention there was some documentation. Did you review that documentation that was included?
I briefly looked over it. I could not find any information on it, just documents.
Okay.
I can't remember exactly what it was.
But it was nothing that stuck out or had a name, correct? Okay. And you mentioned there was some methamphetamine as well as a scale, is that
Yes,
correct?
yes.
Okay. Based on your training and experience as an officer, the scale, did you believe it went with the meth?
I believe so. Yeah.
Okay. Was it a digital scale?
Yes.
And the methamphetamine. I'm gonna show Your Honor what's been marked as people's proposed exhibit number 4 to defense counsel. Motion to approach, Your Honor. Thank you. Trooper Myers, I'm gonna have you look at proposed exhibit number 4 while, and just let us know if you recognize that photo
I do.
and how you recognize it.
It's from my body camera again.
Okay, and what's depicted in that photograph?
It's a little plastic, clear plastic container that has methamphetamine inside of it.
And would you say that that photograph is an accurate depiction of the condition in which you found the drugs?
Yes.
Your Honor, asked that this be admitted as people's exhibit number 4.
Any objection?
No objection.
Before is admitted.
Now, Trooper Myers, I'm gonna finish this portion up real quick. At the time that you pulled it out, you believed it to be meth, is that correct?
Yes.
And at some point, were you able to determine that it was in fact methamphetamine? And how did you do that?
I used our True Narc machine, which I'm trained to use back at the Lansing Post that evening. And it tested positive.
And do you know if this methamphetamine has been sent to the MSP lab as well?
It should have been, I believe it has.
Okay, but you're not fully aware.
I'm not fully aware.
Okay.
No, I filled out the paperwork to send it off, and my sergeant chief did that stuff.
Okay. But based on your training and experience, True Narc, it did test positive.
It did test
methamphetamine.
positive, yes.
Okay. Now, I'm gonna show what's been marked as people's proposed exhibits 5 and 6 to defense counsel. Commissioner Cochran. Thank you. Trooper Myers, I'm gonna hand you what's been marked as people's proposed exhibits 5 and 6. Can you take a look at both of those and let me know if you recognize them?
Yes.
How do you recognize them?
They are again from my body camera, and there are 2 pistols that were found inside the safe.
Now, I'm not familiar with ammunition, but is the ammunition also depicted in either of those photographs?
Not seeing the box.
The 2 pistols that you saw, were
Yes.
correct? Okay. And you did see ammunition in the safe, is that also correct?
Saw a box, and from years of being around guns, I know that box was the color of it. Tell from the colors never its ammunition. I believe I read, you could read part of the whatever ammunition it was.
Okay.
Whatever the caliber was, I can make something out through the hole.
Okay, and I know you indicated it was a box. Were you able to hold that box at any point?
Yes.
Did you feel or believe, based on your training and experience with ammunition, did you think that there was ammunition actually present in that box?
Yes.
And did you at any point open the box to check or verify that?
Yes.
Okay, and it did have ammunition in it, is that correct? Do you remember the caliber by chance? Okay.
I believe they matched the pistols that were in there, but I can't recall.
Okay, that's fair. And you indicated there was 2 pistols, is that correct?
Yes.
Okay, and Your Honor, I'd ask that these be admitted if he was exhibits 5 and 6.
Any objection?
No objection.
This 5 and 6 are admitted.
Based on, when you found those pistols, what did you do next?
Continuing on with the traffic stop, I conducted a lead search at some point on both of the pistols.
Okay, and did you find any information on either of them?
Yes, the one black pistol at the time was registered as stolen.
Okay. And did you have any information about the other one?
The other one came back at that time to an owner of the peninsula, Michigan.
Okay.
And it was not registered as stolen.
Okay, and did it being registered in the UPA stick out to you for any reason?
Yes.
Why is that?
It's odd to me that
and that a gun would be locked in a safe. Hundreds of miles away from the Lower Peninsula with another pistol that is finished pistol.
And had the defendant made any statements to you that also made this interesting?
That he was from the Upper Peninsula.
And do you remember the town in which that gun was registered?
No idea. I'd have to look for the notes.
Okay. Is it written in your report?
I don't recall. Could be.
Okay.
I could look at it.
Would that help refresh your recollection?
Yes, it would.
Your Honor, can I get to his report? This is my copy. This is
Okay.
double signed. Please just review that real quick and see if it does refresh your recollection as to the location where the gun was registered.
I've seen this whole thing. I've seen the other one.
Okay. I'll take that back from you.
Sorry.
That's okay. Now, based on the contents that you did find in the safe, what did you do after that?
I tried to conduct more interviews. I try to get a solid story on the safe and why it was in the vehicle. Who it belonged to.
Okay. And were there other people, other officers as well helping you do this?
There were a couple of troopers.
Okay. And without going into the details of the interviews and what you were told, were you able to determine who you believed the safe to belong to?
Objection, Your Honor. I'm gonna object to this lack of personal knowledge, and I think the information, this question would be based on hearsay.
Do you want to respond to the objection?
And it's his present sense impression at that point in which who this particular item belonged to. And probably provide the basis for what he did after that.
Your question again was what?
Was he able to make a determination as to who the safe belonged to?
I would also object to lack of foundation. It's my belief that any information about who the safe belonged to came from talking to people who are not here today to testify. So it's
You would
based
have
on
that
that.
information that I don't have, so.
But that's why I would say lack of foundation as to his personal knowledge as to the ownership of this.
Okay, to the extent that he would be providing information that he got from someone else, you probably need to lay a further foundation for that.
Sorry, Judge.
I don't know where he got this information from, but to the extent that his response is gonna call for some information that he doesn't have personal knowledge of, you may need to lay some further foundation for that.
Fair, and it's gonna be the culmination of an investigation. That's where it's gonna come
Of
from.
his own investigation or someone else's?
His and other officers' investigation.
Okay, well,
I guess, could I ask one question is to what are the basis of this knowledge?
okay, that's fine.
Clear this up. Trooper, did you get this? Did your information regarding the safe come from interviewing the other occupants of the vehicle?
The knowledge of the safe, I interviewed the driver of the vehicle, and then I had two other troopers that were on scene interview other occupants of the vehicle. And that's where they got a written statement for me at that point from those two.
So the information about whose safe this allegedly was came from interviews conducted by you and other officers of of people who were in that car,
Yes.
not from any other knowledge you were able to gain.
Yes.
So I would object to for any further testimony on that because it is his knowledge and his investigation is based on the hearsay statements of the other occupants of this vehicle.
Did you want to respond to the objection?
Your Honor, it would still go to his present sense impression at that time.
Okay, and not being able for the truth of the matter asserted.
Well, it is being honored. It is.
And I'm going to sustain the objection.
Thank you.
Trooper Myers. I'm not gonna get into what specifically was told to you or anything like that. Is there anything that led you independently to believe who the safe belonged to?
So from interviewing the driver, he admitted to me that.
Objection, Your Honor.
Okay, sorry.
The calls for, that's hearsay.
Thank you. Yes, objection sustained.
Aside from the interview, was there anything else, maybe about the location of the safe or anything like that?
So locate the location of the safe within the back seat, where the Mr. Grove was sitting, and his bag was sitting directly on top of the bag or the safe. All his contents in the back seat in that area.
Okay.
You said all the contents of the things on the back seat were the. Mr.
So
Groves-
there was like a, well, you're including the safe, there's a bag on top, and then there's a safe underneath.
Okay,
And then there was some other personal items.
okay.
So it's your understanding that those items all belong to Mr. Grove,
Yeah.
correct? And were you attributing the safe to Mr. Grove as well?
Yes.
Okay, and you had indicated that the majority of the belongings in the vehicle were his, correct?
I'm sorry, can you repeat that?
The belongings in the vehicle were his, correct?
Yes.
Correct. And the other passengers, the two females, correct? They had bags with them, is that correct?
I believe so, yeah.
And did they claim their own personal bags?
Yes.
Okay, and the driver, did he claim any of the contents of the vehicle?
I believe I can't recall, I believe he claims some tools in the bag, but I can't remember.
Okay. But based on your investigation, you did believe that you knew who the safe belonged to, is that correct?
Yes.
Okay. Now, with regards to the body armor, did Mr. Groves indicate to you that he was aware of that?
Yes.
And he admitted that was his, correct?
Yes.
And he had indicated to you that at that time, that's when he told you that he was a convicted felon, is that also correct?
From my recollection of the conversation.
And he knew he was not allowed to be in possession of that, correct? Okay. One thing, Your Honor.
I have a question while you're doing that. Trooper, you said that in the safe, you could cover some pistols, some ammo and documents. I don't know if I caught what, do you know what kind of documents those were?
I don't recall.
Oh.
I honestly, I'm not even don't recall. So.
I have no further questions. Your Honor.
Process, yeah.
So testify that you initiated this traffic stop because the driver had a warrant out for his arrest. And that was for absconding from parole. So the driver would have been a convicted felon as well. And as a convicted felon on someone on parole, it would not have been legal for Mr. Walsh to possess firearms or ammunition either, correct?
That is
And you said you talked to Mr. Grove about the duffel bag and the body armor that you found, correct?
correct. Yes.
And Mr. Grove admitted to you that that body armor was his. Did you ask him about the safe?
I asked him, I believe at some point about the safe and we didn't want to.
Did he deny ownership of the safe?
I can't recall that. I'm trying to recall the conversation which happened months ago, but I believe I read it with Miranda and he said, I don't want to talk about it.
Okay. And say there was nothing on the documents in the safe that would have had anybody's name on it or given you an idea as to
Not that I
who that safe
recall.
was.
Not that I recall.
And that safe was found in a vehicle that was owned by Mr. Walsh.
Yeah.
And you don't have any idea when that safe was placed inside Mr. Walsh's vehicle. You don't have any idea who placed that safe inside Mr. Walsh's vehicle. So isn't it just as likely that it's Mr. Walsh that placed that safe inside his own vehicle?
And I would object that call for speculation.
You want to address the objection?
I'll withdraw the question. You stated that one of the things you noticed about Mr. Walsh when you arrested him or when you detained him is that he had track marks on his arm,
Yes.
and that was significant to you.
Yes.
Why was that significant to you?
For
All right. And you found drugs inside that safe?
I did.
And these. And how long were you on the side of the road conducting this traffic stop? Was it 5-10 minutes, more than an hour? It was a long traffic stop.
Once we got into it, yes.
How many times did you speak with Mr. Walsh?
I don't.
More than once?
More than once. Yeah.
Without specifically talking about what Mr. Walsh said, did he change his story as you continue to question him? To the same.
Yes.
And at the point you were talking with Mr. Walsh, had you told him, before you discussed the safe, had you told Mr. Walsh that he had a warrant out of parole?
Yes.
And so he was aware he was going to jail. I have no further questions.
Just briefly. Trooper Myers, with regards to the drug use, did you also speak to Mr. Grove about his drug use?
I have to watch it. Sorry.
Okay, I have no further questions here.
May the sugar be excused?
Yes, sir.
Thank you, Sugar. You can borrow your next witness.
There's no further witnesses.
Okay, any additional evidence?
Not at this time.
Is the defense presenting any evidence?
No witnesses or evidence from the defense this time.
Proceed to argument.
Thank you, Your Honor. Your Honor, we obviously had testimony from Trooper Myers with regards to this traffic stop that turned into something definitely more than a traffic stop. While investigating the traffic stop, Your Honor, he did indicate that he had found a safe in the vehicle that he believed to be a safe that typically is a hotel wall safe, I believe. While searching the vehicle, he also was able to find a bag that belonged to Mr. Grove. Inside that bag is body armor. Which Mr. Grove did admit to, and further admitted that he was a convicted felon and was not able to possess that body armor, and he knew that at that time. Further, Your Honor, when the officer was finally able to get into the safe that was inside the vehicle, he discovered that there was what he believed to be methamphetamine, and which later tuned for methamphetamine. He found 2 pistols, one that was registered as stolen and one that was still showing a registered owner in the new Upper Peninsula, which is where the defendant had indicated that he also lived. He also, inside that box, found a box of ammunition that was in fact holding ammunition at that time. He was able to do some investigative work, but also believed that the bag that was sitting on top of this safe belonging to the defendant, as well as the defendant's multiple other belongings in the vehicle, indicated to him that the safe belonged in fact to the defendant. Therefore, Your Honor, the contents of that safe also being attributed to the defendant. Right now, he's charged with 1 count of controlled substance possession of methamphetamine, 1 count of carrying concealed weapon in the vehicle, 1 count of possession by a felon of a firearm, and 1 count of possession or use of body armor by a felon. Your Honor, I think that there has also been sufficient testimony for which to include a 2nd count of carrying concealed weapon. So for count 5 of carrying concealed weapon, as well as an added count 6 of felony possession of ammunition. We have admissions from the defendant that he was in fact a convicted felon, not able to be in possession of these types of things. And I would ask that he be bound over as charged. Obviously, the habitual offender third offense notice just follows to the circuit court. Thank you.
Your Honor, on behalf of Mr. Grove, I would ask that the court not to bind the case over on count 1, count 2, count 3, or the added count 5 and 6. Essentially, the 5 counts that the prosecutor is requesting that amount to the contents of the safe that was found in Mr. Walsh's vehicle. There's been any testimony today to establish even probable cause to suggest that safe belongs to Mr. Grove. Certainly his duffel bag was in the vehicle where the safe was found. However, that was the only item in the vehicle that the testimony reflected Mr. Grove admitted to being his and having any knowledge of. There's been no testimony as to how the trooper came to the conclusion that the safe belonged to any specific person. In fact, from the traffic stop and the position of people, I think it is actually more likely that safe actually belongs to the driver of that vehicle. It was his vehicle that was found in. He certainly, from the officer's testimony, gave multiple statements with regard to the safe, not specifically talking about what they were, but that it was a different statements every time. That suggests that Mr. Walsh had some knowledge of the safe and some knowledge of its contents and was attempting to minimize his connection to it. But certainly, from the evidence presented at this examination, I do not believe the people have provided sufficient probable cause to suggest that the safe that Mr. Grove had connection to the safe that was found in the vehicle, which contained the firearms, the narcotics, or the ammunition. I would defer to the court as far as count 4 based on the testimony that was heard, which is the possession of body armor by a felon. Although I would ask the court also not to bind over on that count, because that count requires that probable cause be established that the defendant was an individual who was convicted of a violent felony at the time that he possessed body armor. The only testimony in relation to Mr. Grove's criminal record presented at this exam today was that Mr. Grove is a felon. And that statute actually specifically refers to violent felony. And since we don't know the nature of Mr. Grove's record at this time, I would ask that the court not bind over on that count either.
Thank you. Any of the argument?
There.
Okay, the court has heard testimony today, the time of the preliminary examination from a trooper, Daryl Meyer from the Michigan State Police. So Mr. Grove, for your information, at the time of examination, the burden is solely on the prosecution. They have to establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. The burden is flexible. The court is the sole determiner of the credibility of the witnesses, and that flexible burden is a common sense burden based on the evidence and testimony presented at today's examination. This burden of probable cause is not to be compared to the burden that the prosecution would then have to establish if this matter was to move on to a trial. At the time of trial, it's beyond a reasonable doubt. So this is a much lower burden. We heard testimony again from Trooper Myers. He indicated that on the date of March 25th, 2022, in the area of Miller and Winterset, which is in the city of Lansing, Ingham County, state of Michigan, they continued before this court appropriate that he was in the area patrolling, and that there was a traffic stop conducted after the plates of the vehicle that caught his eye due to numerous violations was ran to ensure that it didn't meet or wasn't a stolen vehicle that had been being investigated. The officer testified that the plates came back registered to an individual who had a warrant for parole. During that stop, he did testify that he made an observation of some body armor. I think there was some exhibits. An exhibit that was admitted by the people, which show a photograph in People's Exhibit 1 of a body armor in question. He testified that the defendant, or the person he identified as the defendant, Mark Allen Grove, admitted that the body armor was his body armor. The trooper testified that there was a safe that was in the back seat next to the defendant, behind the driver. That on that seat there was also a bag which belonged to the defendant and some other items that he said belonged to the defendant. That he questioned about the ownership of the safe, and specifically requested or asked the defendant about the ownership, and that the defendant indicated he didn't want to talk about it. The trooper stated that he could see through some holes in the back of the safe, and believed there to be what he saw to be a firearm. Therefore, K9 unit was alerted or arrived to sniff the contents of the safe, and it alerted to the presence of narcotics. The safe was opened and the officers recovered 2 pistols and ammunition, documents, and scale and substances that tested to be methamphetamine via True Mark. And so the defendant has been charged with count 1 of controlled substance, possession of methamphetamine, ecstasy, count 2, weapons carrying concealed, count 3, weapons, firearm, possession by felon, count 4, weapons, body armor, possession used by violent felon. And the defense is arguing that there is insufficient probable cause as to the ownership of these items. The testimony of the officer was that the items that were found in the safe was sitting in the back seat next to the defendant, but that some of the defendant's other items were all located in that area. He essentially stated everything in the back seat belonged to the defendant. The defendant, although he did admit to owning the body armor, when he was asked about did he own the safe, he didn't want to talk about it. And he, I guess, could have said it wasn't mine if it wasn't his, but he decided then to assert his right to remain silent. And so the court is satisfied that there is sufficient probable cause as to count 1. Again, all the items for the information or testimony of the trooper other items were determined to have belonged to the defendant, and this safe being amongst those items. So I will bind over as to count 1, controlled substance, possession of methamphetamine. Count 2, weapons carrying concealed, will also be bound over. The people are requesting a second count of carrying concealed. There was 2 firearms located in that safe. I will grant the request to add a count 5 of carrying concealed, and that will be bound over to the circuit court. Count 3 is weapons, firearm, possession by felon. The defendant admitted to the officer that he was a felon, and that he was not supposed to be in possession of the body armor. So the admission of him being a felon, the court will find there's sufficient probable cause as to count 3 and count 4. Although the statute says a violent felon, there was an admission by the defendant to the trooper that he was not supposed to be in possession the body armor. So count 4 will be bound over to the circuit court. There is a request to add a count 6 felon in possession of ammunition that will also be granted and bound over to the circuit court, along with the habitual offender third offense notice. Your bind over date is going to be June 8th, 2022. You do not need to appear in court on June 8th. That's the date circuit court gets the file from the district court. Your next court date in circuit court will be a pre-trial, and Mr. Nichol will be made aware of that date. So you'll remain in contact with him, okay? Okay.
Yes.
Okay. And then you won't have an arraignment in the circuit court unless Mr. Nichol makes a motion to the circuit court for that purpose. I don't see why you would do that because you're out on bond, but there may be some other issues he may feel like he needs to address. Do you have any questions at this time?
No.
Any additional matters for the record?
Nothing for the people.
Nothing from the defense.
Continue. We're off the record. You need to sign this one? Oh, okay. I think it's already up.